Do I have to tell my disability carrier plan that I'm collecting unemployment benefits? While the disability carrier plan was fooling around, deciding whether or not you were entitled to benefits, you may have applied for unemployment compensation benefits to keep the money coming in. I get that. So what is your legal obligation to tell the carrier of the plan that you've applied for or are getting unemployment benefits? Now, there are two considerations. The first consideration is that most disability policies or plans require that you cooperate with them. And part of that cooperation is giving them any information that they are reasonably entitled to. The second thing is if there is an offset provision or other income provision in the disability policy or plan that lets the carrier reduce your benefits by the receipt of unemployment. So let's take these apart. Obviously, you want to get out your policy or plan and read it. But most of the time, they will say that you have a duty to cooperate, and the failure to give the carrier or the plan a copy of your unemployment application, copy of your job search, a copy of your checks can be a breach of the policy or plan. They may even ask you to sign a release that lets them contact your state unemployment office to get unemployment information. Your failure to sign the release, your failure to give them this information can be a breach of your duty to cooperate. And that means that they can deny your benefits based on your lack of cooperation, notwithstanding how disabled you might be. Now let's talk about the offset provision. Each policy or plan is unique, so you want to get yours out and read it under the offset provision section or other income section. Now, the offset provision, as I said, can differ from policy or plan to plan, so you need to understand what it is. But generally what you will see is that there is a dollar for dollar reduction for every dollar of unemployment benefits that you get. It's going to reduce the amount of your benefits. But the other problem that we have is the carrier plan may seize on this unfavorable unemployment decision to say, hey, you're not disabled. You admit you're not disabled because you filed this unemployment claim. As part of filing an unemployment claim, you're saying that you're able-bodied and able to work. And so there's this contradiction between a disability application that says I can't work and an unemployment claim that says I can work. The disability carrier plan can seize on that and say that regardless of how disabled you might claim you are, you obviously didn't think you were disabled when you applied for your unemployment benefits, and you're just double dipping. And sometimes they'll deny the claim for just that reason. I understand that your financial circumstances may have been dire and you needed this money, but before you apply for unemployment benefits, I think it's crucial that you not only get a copy of the policy or plan, but talk to an experienced ERISA disability attorney about your particular circumstances. Give me a call at 727-894-3188 for a complimentary consultation.